the previous video, we examined the major methodological approaches adopted by comparatists. In this video, we are going to move from theory to practice, and we are going to see how we actually perform a comparison. Because comparative law is not just putting side by side two legal systems, it requires a structured process involving several stages. According to Constantinescu, comparison can be made, or the process of comparison needs three stages, which he calls the rules of the three C's. Because in French, they start with the letter C. Connaître, comprendre, comparer. To know, to understand, and to compare. But before, as a preliminary step, we have to select the elements we are going to compare. Therefore, we will discover together four stages. First of all, the preliminary stage of selecting the elements of comparison. Then, knowing the systems we are comparing, or the legal systems we are comparing. Then, understanding them. And finally, comparing. So, the preliminary step, which consists in selecting the elements that will be compared. It may appear obvious, right? First to select which countries or which systems we are going to compare. But it is one of the most important decisions in any comparative project. So first, it requires at least two elements to compare, but also it requires a third element known as the tertium comparationis that will play a central role in comparison. So first, the compared elements and then the tertium comparationis. Compared elements. Many questions can be asked before we select the compared elements. Several choices must be made. So first of all, which legal choices are we going to select? Which legal systems? Usually when we speak about comparative law, we are talking about laws of different countries. So sometimes it is possible to compare between two legal institutions within one system, but it is not generally considered as comparative law. So in comparative law, we need at least two systems from two different countries. Comparable. Okay, so first of all, we need to compare two laws or two legal institutions or two legal solutions or phenomena from two different countries. And these two phenomena or legal rules or institutions must be comparable. And usually we have to limit the number of compared elements. For instance, if I tell you I'm going to study the contract of mandate in the Lebanese, Syrian, Egyptian, French, English, Sudani, Australian law, it will be too much. I will drown in the quantity of details, and I will perhaps have troubles finding out a suitable conclusion, an efficient conclusion. So we have to limit the number of compared systems and think wisely about selecting them. As we will see, what also will affect or will help us into selecting these countries is the tertio comparationis. Why are we comparing, in other words? Or what are we comparing within these two systems? For instance, if I want to compare, if the topic of my comparison is irrevocable mandate, then I should seek systems where they do have a contract known or close to mandate, and where there is a practice of irrevocable mandates. For instance, I can compare between Lebanon and France, where they do have an irrevocable mandate, but where in fact it can be revoked, but by paying a certain compensation. So after comparing the elements, we can also we must think about the scope of comparison. And will it be a micro comparison or a macro comparison? As we saw, structural studies usually go toward macro, while functionalism go toward micro. And then we have to decide, are we comparing systems, the Lebanese system vs the Australian system, or family of systems, or even traditions. Now, we are not going to talk too much about these issues. They will be the topic of our third encounter. But usually, I can compare the whole Romano-Germanic families with the common law family of systems, or I can compare one system from here, one system from there, or two systems from the same family. So also I have to decide, I have to make choices. So this is about making the first choices, the preliminary choices. What am I going to compare? And then I have to take into consideration the uh, tertium comparationis, which is an important concept in comparative law. It means the third element of comparison. It is the factor that links or the common ground between two elements in comparison. Let me show you a simple example. We have here the elements we chose are elements A, B, and C. I can pick as a tertium comparations as a criteria for comparison either T, T1 or T2. Suppose I take T, then I could say that between, or suppose I take T2, excuse me, as a tertium comparationis, I can say that A, B, C have a similarity, which they all have a quarter of T2. But if I take T1 as a criteria, then I will have to say that B and C together are different from A in the sense that while A has T1 in the color purple, B and C have no color purple. But if I take T, the yellow color, as a tertium comparationis, here I can say that A and C do have yellow, which separates them from B, but also between A and C, there is a difference in intensity. While T is present in A, and as you can see, the color T here, the bright yellow, is present in A, but in C, the yellow is lighter. So we do have yellow in both A and C, but the yellow in A is brighter. So here we can compare the intensity between these two elements. This slide, you can pause and read the slide. This is what I just explained. So full similarity is really rare, right? So often we see cases like A and C when it comes to comparing whether they have or not the color yellow. So we can say both have the color yellow, but in less intensity in C than in A. Here, and before I continue, the comparatist must choose sometimes an equal position. Am I looking for similarities? And am I starting from a presumption of similarities or from a presumption of differences؟ يعني هل عم بنطلق من افتراض similarity أو من افتراض differences. So we have to choose. Pierre Legrand, for instance, the comparators that we have seen in many places so far, Pierre Legrand says, no, we must always begin with a presumption of difference, that the aim is to mark differences between legal systems. Whereas Weigert and Coates, two eminent German comparators, say no, should always begin with a presumption of similarity and try to prove similarity. Right? So the aim is to show the universality of legal rules. Whereas Pierre Legrand, who is from the hermeneutic school, if you remember, Pierre Legrand say no. The purpose of comparative law is not to show unity, because this unity does not exist, because every system stems from a different mentality. Therefore, the purpose of comparison is not showing similarities, but understanding differences. Okay? So, first, the first stage, the preliminary stage of selecting the elements, we must get to know these elements and the legal rules within each system, accessing the legal information. We must know how to access the legal information. So sometimes we may face some logistical problem. If I want to do a comparison, let's say, between Lebanese jurisprudence and Egyptian jurisprudence, it might be difficult for me to find Egyptian jurisprudence or to understand the sources in which it is usually written. For instance, for a long time, Saudi Arabian law was a bit opaque, so it wasn't transparent, so it was difficult to find Saudi jurisprudence. Things changed today. So therefore, when I'm thinking about my comparison project, my comparative law project, I must take this into consideration. How easy the access to the laws will be, and what will it cost me to get access to that law? And of course, we must take into consideration the theory of sources in each system to know where to look, where to find. For instance, if I want to look into a legal phenomenon in France, I know first I look into the laws, then into the jurisprudence, the case law, and then into the doctrine. Lebanon would be the same. But if I want to seek something in Islamic law, then I won't find perhaps in laws. I would go through the classical treaties of Islamic law. So I must know the theory of sources related to each regime to know where to look for legal rules. And where are these legal rules? Okay. And for instance, if I'm looking into some tribes in Amazonian forests or in Central Africa, I may have to find these legal rules in their customs and not in laws or case law. I don't know if you understood the idea. يعني كل نظام عنده source de droit تبعه، مصادر القانون. فأنا لازم أعرف شو هي مصادر القانون تقدر أعرف وين بدي ألاقي قواعد القانونية اللي عم نبش عليها. لما يكون الريسيرش تبعي ضيعان يعني ما لها معنى. Usually primary sources, at least in the Romano-Germanic system, laws and statutes and whatever, we can find them in official references such as the official gazettes, يعني جورنال officiel, جريدة رسمية, or in some reputable journals or publishers. In common law systems, case law is usually contained in what we call reports. Reports that contain all the case law either of the US Supreme Court or other courts, federal courts or state courts or the England courts, etc. We can find them in what we call reports or reporters. Okay, so we must have an idea where to find the legal rules we are going to compare. This will necessitate a preliminary study of the theory of sources in each system. So we found the laws. We were able to find and access to these legal rules. Now we have to understand the foreign law. Here, secondary sources play a bigger role. Which by secondary sources I mean doctrine. Doctrine will help us to know what is it really about, to really understand the meanings and the solutions of the real meaning of every legal rule. Sometimes reading the codes is not enough. For instance, if a legal comparatist reads Article 131 from the Code of Obligation of Contracts, he will not get a real view of what Lebanese law says in terms of accidents between movable objects. He will have to read what case law and what doctrine says about that as well. Now, reading the rules as they are in codes is not enough, because sometimes written rules in codes, يعني القواعد القانونية المواد القانونية بالقوانين are not applied as they should. We have to take into consideration how they are really applied to get a realistic knowledge of the legal system we are studying. The importance of the cultural component. This is an influence of the cultural approach. We have to know the culture of the country we are comparing, and therefore the importance of interdisciplinarity. We must also bear in mind the legal differences, the linguistical difficulties, because legal language is technical. And there's lots sometimes of words that may seem to have the same meaning, but they don't. For instance, I just give an example, I think in this video or the last one, jurisprudence. In French, jurisprudence means case law, اجتهاد. In the English legal language, no, it means doctrine. And it meant that in Roman law before, while in French law it means case law. It means case law. So we have to bear in mind that even if apparently two words in English and French might look the same, they may not have the same meaning. Especially, it gets even more complicated when it comes to translation. So, knowing and understanding, and we access the law and we have to understand it. Gambaro, Sacco, and Vogel, also comparatists, speak about what they call the legal formants, formant juridique, or legal formants. By that they mean what forms the legal system. It could be the classical sources of law, such as judiciary case law, laws, customs. It also means argumentation and methods used in reasoning. For instance, the syllogism, the role of syllogism in the Romano-Germanic system compared to the case law thinking or case law methodology, which is and we'll see it later on in Anglo-Saxon systems, in common law reason, in common law systems, sorry. Legal practice drafting techniques are also included in these formats. Again, I will give the same example. The irrevocable mandate, الوكيل الغريب للعزل, in the COC, in the Code of Obligation and Contracts, we find only 2 articles related to it, while the importance of irrevocable mandate in Lebanese law comes from practice more than from the legal rules. Also, what enters into these legal formats are what legitimizes the sources of a rule. For instance, in Islamic and religious systems in general, it would be God or the holy books. And in royal Europe and in monarchies in Europe, what would legitimize the law is the monarch, the king himself, because he was looked as a having a divine mission, in a monarchie de droit divin, as they used to call it. Also, it may include cryptotypes, and by cryptotypes we mean the implicit formats, the mentalité of a certain legal profession or a legal community. So when we want to understand the legal system of another country, we have to identify the formats of this legal system. The classical sources, but not just the classical sources, even the implicit methods of thinking, argumentation, reasoning, practice, the role of legal practice, and if you want also what the underlying legitimizing elements of the system, the powers that legitimize the system as a whole. So after the first C, connaître, to know, the second C, comprendre, to understand, we now get to comparison. Here just a few simple advice. Avoid the anecdotal. I'm sure what is anecdotal will inevitably seem more interesting at first, but you cannot compare just what is anecdotal, what appears most, right? We have to go behind the surface. We must avoid comparing isolated rules, and we already spoke about this many times. And when I'm comparing 2 rules, I cannot just rely on the rule as it's written in a code. I have to understand how the legal system understands it, how it interprets it, and how it applies it by case law and doctrinal work. And also every rule must be taken into its context. And finally, to keep the goal of the comparison in mind. Uh, I'm going to jump to another point which I already mentioned, is the standpoint of the researcher. As I said, the researcher could start with the presumption of similarity or with the presumption of dissimilarity. I'm not going to explain more since I already did. Now I will talk about something important, an important tool used frequently by comparatists, models. النموذج, le model. So comparatists usually and often resort to models. They use models in their comparative research. They may create new models or adapt existing ones or just use existing legal models. So what are these models? How models are created? And we'll see examples of models. To start the discussion, I can ask you a question and you may reflect on it. If I tell you to ideally represent a Lebanese Sunday lunch, right? You may think of a Lebanese meza. You will tell me that this meza will include this and this and this and this kind of food. It may include this kind of drink. It may include that. It may include a barbecue. It may include family being together, which means grandparents, grandchildren, etc. It might include listening to songs by, I don't know, Melhem Barakat or Fairuz or whatever. But this will be an idealistic model. So all the elements you will think of will never or will rarely happen to be a reality at every Lebanese Sunday lunch, right? Perhaps in this Sunday lunch you will have fish, and the other you will have kibbinay, you will have whatever. But I give this example to illustrate the difference between an idealized representation of a phenomenon and the phenomenon itself. So when I create the idealistic representation of the phenomenon, it will help me identify if this phenomenon can be considered as a Lebanese Sunday lunch or no. But it doesn't mean that in every Lebanese Sunday lunch, all these elements must be present. The same with models. When we create models to identify and to grasp reality in order to control reality. But models are idealized representations. They are even a simplification of reality in order to grasp and understand reality. So models are never there in real life as they are, and we can rarely expect to find a model just as it is in real life, but it will help us compare. So a model is an idealized, and we can call them simplified representations of legal reality. They are neither a complete description of reality nor a purely imaginary construct, though. They are not imaginary. They are based on induction, but also they are not a complete description of reality. So they occupy an intermediate position between observation and theory. A model is a structural combination of elements designed for practical application in order to solve a particular problem. Halfway house between data and theory, or in more simplified terms, it is an idealized theoretical framework or abstract construct used to represent and analyze legal systems. How models are constructed? They are constructed by induction. Induction, as compared to deduction, induction is when I observe a big number of cases and phenomena and try to induce a general rule by that. For instance, when Newton discovered the law of gravity, Newton was observing many cases, like how an apple would fall on the ground, how if I leave a paper, it will fall on the ground, how if I leave a feather, it will fall on the ground, if I leave a cannonball, it will fall on the ground. So by observing all these cases, he induced a rule, a general rule of physics, which is gravity. Induction is like that. And this is induction. Induction, to answer, for instance, the question that I asked before, how would you picture an ideal Lebanese Sunday lunch? You would think of all the Sunday lunches you had. And then by induction, you would say, oh, and almost in the majority of these lunches, we had kibbinay. Okay, so kibbinay would be an element of a Lebanese Sunday lunch. We had ara would be, etc. Perhaps not in every Sunday lunch you had ara, but in most of these Sunday lunches you had ara. So by induction, you say, okay, so probably a Lebanese Sunday lunch would be characterized by kibbinay, ara, etc., etc., etc. This is induction. In Arabic, we call it al-istinbat or al-istiqra, induction, compared to deduction, istintaj. Deduction is we have the rule, we apply it on a particular case. So a model is constructed by induction. We observe reality. For instance, we observe how most contracts are concluded. We observe how most people treat their ownership. We observe how in most countries the legislator creates law, and then we try to modelize it by abstraction. يعني بنجرد من الامور السبستانشال او مش سبستانشال عفوا الكونتنجنت elements، يعني الامور الظرفيه ما بنترك الا المبدا. Models are used to understand the legal phenomenon, to compare and to classify. Perhaps by giving examples it will be clearer. First example, the judicial review or constitutional review or constitutional control of laws. يعني الرقابة الدستورية على القوانين. If we observe by induction again the different systems of judicial review, we can find many models, many ways of it. For instance, we have the USA model, which is the oldest when it comes to judicial review. It is a diffused or decentralized model, meaning every court has jurisdiction to review the constitutionality of laws. It is concrete, meaning usually the question about the constitutionality of a law is asked during litigation, not in abstract. And the consequence is to block the enforceability of the law. It's not annulment, but blocking its enforceability. So we can no longer enforce the law that was considered as unconstitutional by the Supreme Court or by any court. In comparison, the French model before 2008 was totally different. It was centralized. Only the Constitutional Council had jurisdiction, was competent in constitutional control. The only way to attack a law because it's unconstitutional, because it goes against the Constitution, was in abstract way, not during a litigation, but before the law was promulgated. And the consequence was annulment. The Lebanese model is closer to the French model. The new French model after 2008. In 2008 in France, they introduced something called la question prioritaire de constitutionnalité, priority question of constitutionality, allowing every citizen to ask, but not directly through the judicial hierarchy, a question of constitutionality, which now makes the French system something hybrid between its old version of itself and the American model of constitutional review. By creating the models, we can thus compare. Like we can talk about a diffused model of constitutional review. The diffused model means every court has the right to assess the constitutionality of a law. In France, it is not diffused because only the Constitutional Council can say that. But courts can send the question to the court. So we create a model and we compare according to that model. It's a concrete model. Is the constitutional review in France concrete or no? Today it became concrete, yeah, but before it was not. In Lebanon, no, it is not concrete. In Lebanon, citizens are not allowed, if they are in a case, suppose a Lebanese citizen is sued, and the law upon which he is sued is unconstitutional. The Lebanese citizen has no right to call it out. He has no right to ask for a review of the law. The law must be applied to him. Only a certain set of persons identified in the Constitution can attack a law because it is unconstitutional in 15 days after its publication. You already know that. You saw it in your introduction to law course. Another example, property. We can think of two idealistic representation of property, two models of property. The communist model of ownership, النموذج الشيوعي للملكية, which denies private ownership of means of production. يعني بالنموذج الشيوعي للملكية الأفراد منهم قادرين يكونوا مالكين لوسائل الإنتاج. في عندنا theoretical model of absolute private property هذا اللي أيضا يعني الإنسان بيكون when you own something, you have a full control on it. Now, none of these two models exist in reality. In the Soviet Union, there were ways for citizens or for firms to be owners of means of production. In the American system and the Lebanese system, which are considered like two liberal systems, private ownership still has certain limitation by the law. Okay, so these two systems are never found in real life as they are, but they help us compare. For instance, if I want to take the private property system in Syria, I can say it is as it was before. I don't know how it is today with the reforms, it might change, but how it was under the Assad regime, it was closer to the communist model than to the absolute private property model. Lebanon is closer to the absolute private property model than the communist ownership, without being a full liberal absolute private property model. Finally, another example, it relates to the theories of intent and intention in contracts, will, al-iradi. You may have seen it in contract law, you may remember it from contract law, but there are three models when it comes to defining what we mean by will or intent. يعني شو المقصود بالإرادة؟ هل هي الإرادة المعلنة declared intent, or is it the true intent, or is it dictate, or is it behavior? يعني we should rely on behavior rather than on declared or psychological investigation of the mind. And when we speak about declared intent, it means that whatever you declared will be considered. Even if internally you had different thoughts, you had a different will. So if you wrote in the contract that I agree and I want this, it will be considered as your declared intent, and it will be the only intent taken into consideration by the legal system. In the true intent model, it doesn't matter what you have written or declared. What matters is your true psychological disposition. So it is much difficult to prove it because the judge will have to interrogate your psychology, right? We have to investigate your psychological situation. The behavioral model says that no, we don't go through a psychological investigation of the mind, and we do not just rely on what has been declared. We see the overall behavior of the subject. Did it really want to be engaged in a contract or no? So these three models are never existent as they are in practice. The Lebanese system is closer to the true intent model. But even in the Lebanese system, it doesn't allow to annul or avoid a contract every time your real intention is different from the intention you declared. Vices of consent, vice du consentement, يعني عيوب الرضا, go in the sense of the true intent model. إذا أنا إرادتي كانت معيوبة ببطل العقد. ليش؟ لأنه المهم هو إرادتي الحقيقية مش الشيء اللي بين بالعقد. However, that doesn't go all the way. يعني there are certain تناخد الغلط الإيرور. في عنا غلط لا يؤثر، في عنا غلط غير مؤثر. يعني هنا في أنا بتكون إرادتي من إرادتي الحقيقية غير متوافقة مع إرادتي المعلنة، بس إذا كان الغلط غير مؤثر العقد بيضل. So Lebanon is very close to the true intent model, but it is not a pure true intent model, because not every time there is a difference between true intent and declared intent. But it's not that every time we will avoid the contract. Sometimes, even if true intent is different than the declared intent, the contract will be allowed to live. So all these are to explain to you the notion of model. So a model is a representation of reality, a simplified representation of legal reality, which does not necessarily exist in real life, but helps us to compare and to classify. The next two slides, I will leave it for you to read them. I will explain them quickly. In this slide, also taken from a book from Geoffrey Samuel about methodology, he distinguishes between what he calls genealogical comparison, meaning comparing through history, and analogical comparison, and in comparing without taking into consideration the historical evolution of the law. And finally, the same author also speaks about three ways of validating an assertion. Because if you are doing a comparative research, you will have to formulate an assertion, a hypothesis. How can you validate this hypothesis? Either in a realist way, meaning it corresponds to reality, or by a formalist way, you rely on logic, on internal logic, or by consensus if most the doctrine has reached the same conclusion. Okay, so I will see you in the next session.